Counsel, in each of the cause numbers, have you received all discovery? Did you review it with your client?
Yeah, I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, in each cause number, did you review the application for community supervision with your attorney? Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
State, are you proceeding on I'm sorry, defense, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictments as presented?
Yes, Your Honor.
And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And the cause number ending in 7-1, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 8-2, you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, in each cause number, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Gonzalez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Understand it?
Yes.
All right. And the cause number ending in 7-1, according to your plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State is recommending community supervision. And in cause number ending in 8-2, punishment is to be assessed at 2 years in the prison. There's a $2,000 fine. State recommends community supervision, and the cause numbers are to run concurrently. Did you understand that to be your plea?
Yes, ma'am.
Defense and state?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be 200 hours of community service restitution, a TAP evaluation, DOEP, job skills, and MRT course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the cause number ending in 7-1, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause ending in 8-2, how do you plead?
No contest.
State any evidence.
State offers states one and attachments in each cause, Your Honor.
Your Honor, if it says no objection to either.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. And the cause number ending in 7-1, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would like to, Your Honor.
All right. Anything you wish to say on behalf of your client?
I would, Your Honor. As you can see by her incarceration, I was court appointed. We'd asked the court to find that she is indigent, and asked just for any help on the either monthly probation fees or the fine. If she could probate any. She does have a high school degree, but not a college degree. So work will likely be at some type of minimum wage job in customer service. So any help on the fines and fees would be greatly appreciated. Thank you, Ron.
Right, you're welcome. Well, maybe not. We're not going to put it in the universe that she'll only be able to get a minimum wage job.
No,
So do you have any children?
No.
Do you have any family support?
Just my boyfriend and his family.
All right. And what's your drug of choice? What have you been using?
Meth.
How long have you been using meth?
About 5 years.
When did you, well, what made you start?
It was my baby daddy. He put it in my arm
Okay.
forcefully, and then I just kept doing smoking it after that.
Okay. So where are your children?
They're all grown. They're big. They're doing their own thing, doing their
Okay,
job.
so why when I asked you if you had any children, you said no.
Oh, I don't have any with me, like under. I'm
So
not,
are they living in San Antonio or somewhere else?
they're living in Dallas
Okay.
and Austin. 2 of them is in Austin, and the rest of them in Dallas.
So do you have any grandchildren?
No.
All right. So this household with just other boyfriend, are there any children in that household?
No,
And how long have you known him?
3 years.
And how did you all meet?
Through a friend. It was at a party.
Mhm. And other than injection, is there any other way that you've used drugs?
Just smoking it.
Okay. And what drugs did you smoke? The same?
meth, the same.
All right. And do you have any violent history in your past?
Do I have what?
Violent history?
No.
Any gang history?
No.
All right. And that cause number, this is what I'm going to do. The court is finding you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, $2,000 fine. That will be probated. That will run concurrently with 2026 CR 000382. There's going to be 200 hours of community service restitution. I'm going to order the job skill course. Once she completes that, 100 hours of the community service will be deducted. The remaining hours will be deducted. Every sober support meeting you complete, an hour will be deducted. In custody, there's going to be a referral to felony drug court and TAP evaluation, follow recommendations, proof of employment within 45 days of release, no employment as a home health care provider or with minors, no residing in households with minors. Probation, is there anything else? Thank you. Field visits 1 time per month until further notice. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because that's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, next we'll proceed in the other cause number. And that's cause number 2026 CR 000382. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And the court will find you guilty. Are you proceeding with sentencing?
yes, Your Honor.
And that cause number, the court will sentence you to 2 years in the prison, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, $2,000 fine that will be probated. This will run concurrently with 2026 CR 003371. There's to be $200 hours of community service restitution. 100 hours will be deducted for the job skills course, 1 hour deduction for every sober support meeting completed. In custody, refer to the felony drug court, also a TAP evaluation, follow recommendations, proof of employment within 45 days of release, no employment as a home health care provider or with minors, no residing in household with minors, and field visits 1 time per month until further notice. All right. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it in that clause number?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement.
This is the moment where the hearing shifts from legal procedure to personal responsibility. The sentencing decisions have already been announced, but Judge Boyd is now focusing on something equally important: whether the defendant can successfully avoid returning to the same patterns that brought her into court. Notice how the judge emphasizes the connection between stress, unhealthy relationships, and relapse. That's a critical point in many recovery-focused court programs. Rather than concentrating solely on punishment, the court is highlighting the practical challenges that often threaten long-term sobriety. The judge also points toward felony drug court as a resource designed to provide structure, treatment, and accountability. Here's a question for viewers. Do you think recovery becomes significantly harder when someone remains surrounded by the same people and circumstances that contributed to their addiction? This exchange offers insight into the court's broader goal before we return to the proceedings.
But I'm going to sign the referral today, and they'll be able to see you first thing next week.
Okay.
And if you're honest with them, they're going to accept you into the program, and they will work with you on getting housing. Okay? Because, again, things that I've noticed, sometimes when people have this boyfriend, and you're living with the boyfriend in his mom's house, then you know what that means? He can't even support himself because he's living with his mom. And that's going to cause drama and trauma, because usually, guess what? There can only be one queen be in the household, right?
Yes.
And I'm sure his mom likes things a certain way, and she's probably tired of her son, who doesn't even have his own place, bringing other people in the home, mouths to feed, okay?
I understand.
Yes.
So we do have our own place. We just got it.
Oh, well, that's awesome. Then you won't be staying with his mom.
No.
All righty. All right, good luck to you, okay?
Thank you.
Take
All
care.
right, you're welcome. 2023 CR 10135, State versus Adam Gonzalez. Can I have parties announced?
ADA Jones for the state.
Related Castañon for defense.
And are you Mr. Gonzalez?
Yes, Your Honor.
All right, defense, you filed a motion to set bond on the motion to revoke community supervision.
Yes, sir.
All right, you may proceed.
Judge, my client is asking that he be allowed to make a bond on the motion to revoke. He has some affairs that he needs to tend to, and we're just requesting that you set bond. The previous amount was $10,000.
State.
Yes, Your Honor. My understanding, and I am trying to pull it up, but Odyssey is being difficult. My understanding is that right now he is remanded without bond. He is not entitled to a bond, as this is not a deferred adjudication probation. Additionally, one of the allegations in the motion to revoke probation is not reporting, and I believe it was not reporting for over a year. So the state does believe that this defendant is a flight risk. Additionally, while on probation, the defendant picked up a new number 1 for assault against the same victim that is alleged in the case he's on probation for. Further, he does have another case out there for ag assault deadly weapon, although that case is being filed at large. That is also with the same victim. So not only is this defendant a flight risk, but he is a danger to this victim and potentially to the rest of the community, Your Honor. And so the state's asking that the court remand him without bond.
All right. So with regards to the new law, with regards to setting bonds, if the state is able to present to the court evidence of a prior assault and also or prior violence against the same alleged complainant, then he's denied bond.
Okay, well, Judge, in regards to that, I believe that he's currently on motion to revoke. He's on probation for a nonviolent offense. So,
And just a very brief response, Your Honor. That is correct. However, if it is for unlawful possession of a firearm by felon. However, if you look at the stipulations which the defendant stipulated to, there is family violence alleged in that with this victim, including with the weapon.
All right. Does anyone have the stipulations? I do see as a part of the court's orders, there was a no contact order against someone.
I believe that is in the clerk's notes.
Yes, Your Honor. I can print them if Your Honor will give me just a moment.
Your Honor, permission to speak.
You may want to speak to your attorney before you speak. Counsel, if you want to have the court accept whatever evidence is presented and then recall this for next week for you to bring whatever evidence, if your client wants evidence brought in, I won't issue a ruling today.
Yes, Judge.
All right. So then and state at that time if you'll have the stipulations.
Judge, yes.
And then what we'll do, what I can tell parties though, since state you are asking that the court deny him a bond, everybody needs to have whatever witnesses they have, because the rules of, even though the law has changed, the rules of evidence and what the rules apply to has not changed. So denying a bond, increasing a bond, the rules of evidence still apply.
And Your Honor, just so I understand, my understanding is that he's currently remanded without bond. So the state's
Yes.
not asking to increase the bond or anything. It's defense's motion to reduce the bond or to set bond.
Well,
And so
when they are remanded without bond,
Mhm.
that is only for a limited time. And the court does that for them to come back in court, is entitled for a bond. Now, if you're saying, Judge, we're not going to ask that he be denied the right to have a bond, we're fine with the bond being set, that's something completely different. But if you as the state is going to say, I don't want him to have a bond,
sure,
then the rules of evidence apply.
sure, that's fine.
Okay.
Judge.
All right.
Yes, Judge.
So when will people be able to have their witnesses? If you'll talk to Ms. Ferguson, and we'll bring everybody in.
Yes.
Now, mind you, if everybody's gonna proceed, and by everybody, I mean state and defense, if y'all gonna proceed like the rules of evidence don't apply, then y'all won't need any witnesses.
It's Judge.
And I'm assuming people are gonna proceed as though the rules of evidence do apply.
Yes, Judge.
Yes,
Okay,
Judge.
so if y'all talk to Ms. Ferguson for when y'all need this set, but it'll have to be next week, because if it's gonna be a contested hearing, I'll give you all 20 days to prepare for a contested. So if y'all speak with Ms. Ferguson on the date to come back on a bond.
Thank you, Judge.
All right, thank you.
We can confer.
Obviously a while.
Odyssey always takes a while.
Mhm.
I think there's a movie coming out called The Odyssey. Apparently it's 3 hours, so even the movie's gonna take a while.
Well, hoping the Odyssey, the movie, is gonna be good.
I'm joking. Our Odyssey is our system that we use,
Yeah.
and it's horrible.
Yeah. Yeah, Odyssey is on
Going
an
on an
Odyssey.
Odyssey.
Hmm?
It should take more than an hour. It needs to take hours because it's an Odyssey.
Right?
Otherwise, it's not an Odyssey.
Yeah.
What would we call it?
Otherwise, it's a trip, a sojourn. Yeah.
No, I mean, it would be something less than a trip.
Around the corner.
There we go. All right, so Ms. Abrams, on this case, you said VTC did not accept him?
Correct. As felony drug court also did not.
All right, so alternate amending, and again, what are we doing?
Adding moral
MRT.
MRT, I don't remember what the R stands for. And
Or recognition
thank
therapy.
you. Yes, Judge. And the a TAP evaluation and follow recommendation.
Probation, anything else? So when will the TAP be done?
We have to schedule.
How many weeks do you think it will be? Out of custody, you think? All right, Norma? Can I have a 4-week reset for an update on his TAP eval? All
June
right.
8th. June 8th.
All right. So this is what I'm going to do. Ms. Abrams, I will go ahead and agree to sign the motion to withdraw. The only alternate amendment I'm going to do today is the alternate amend for TAP. Because I think once I see the TAP evaluation, it'll tell me if MRT and all of these other things are necessary. Are you okay with that, Ms. Abrams? All right, that's what we'll do. And counsel, if you'll stay on the case and be back on June 8th so we can see what's happening with the TAP evaluation.
Yes, Judge. And just to be fully transparent, I am here filling in for Kyle Simpson. This is his client. So it may be him, but
Okay.
if that's okay with you,
Yes.
otherwise I'll be here.
All right, thank you.
Thank you.
So what's happening with this?
We think it might be dismissed, but the state is asking for a 30-day reset.
State, Brianna, are you requiring something from them? For you, she said she think you
Are
all
we
think they dismiss?
Yes, that's right. We're gonna reset to, because I think she has the misdemeanor as well.
Yes, she has a misdemeanor MTR pending next week, so.
Okay. And so,
And I think the resolution of the MTR will resolve this case as well.
all right, and are you on the MTR?
Yes, ma'am.
All right, and you say that's next week?
Yes, ma'am.
All right, Ms. Ferguson, I need a reset date in 2 weeks. All right, May 21st.
Yes, ma'am.
All right, thank you.
Thank you, Judge. Good to
You're
see you.
welcome. Please announce.
Monica Chita for the state.
Orlando Costume for defense.
All right, and are you Mr. Adam Gonzalez?
Yes, Your Honor.
Defense has filed a motion asking that a bond be set.
And I believe,
Just one moment.
I don't think we listed the prior amount.
All right, so is he on deferred adjudication?
He is, Judge.
All right, the docket shows that he's not on deferred. It shows that he's on regular probation.
My understanding is going to defer.
Oh, he's on regular probation.
He's on regular probation?
Yes.
Okay, well then, that was my mistake. I thought he was on a deferred.
Oh, no problem. But yes, so. All right, this judgment is incorrect. All right, so the judgment needs to be corrected, but he's on community supervision. 10 with a 10 underlying.
Okay,
So if y'all step back, the judgment needs to get corrected and then we'll see where we are with regards to bond. All right, that on the
No, that's
ankle,
okay,
you should.
Judge. I'm trying to be a little bit more aggressive in my recovery. They basically said if it hurts, it's fine. If it hurts a lot, stop. So,
Well, let's not get too aggressive with recovery. Oh, and counsel, you're on this side.
sorry.
That's okay.
This hearing ultimately produced a result centered on supervision, treatment, and rehabilitation rather than immediate incarceration. After reviewing the evidence and accepting the defendant's pleas, Judge Boyd imposed suspended sentences in both cases, placing the defendant on community supervision with numerous conditions. Those conditions included drug treatment requirements, community service, employment obligations, regular reporting, and participation in programs designed to support long-term sobriety. Throughout the hearing, Judge Boyd repeatedly emphasized the importance of avoiding harmful influences and taking advantage of the resources available through the court system. The message was clear. This opportunity comes with significant responsibility, and future success depends on the defendant's commitment to change. Cases like this illustrate how courts often balance accountability with rehabilitation when addressing substance abuse offenses. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.